Going live.
All right.
So yes, good morning. Well, it should be in 1 minute. It should be afternoon as we're getting ready for the South Fulton Chambers Lunch and Learn for what is today's day? July. Look, I'm like we losing track of
July
day,
9th.
day, July 8th.
9th, 8th.
I thought it's not.
8th.
It's the 8th. Oh,
Yep.
okay.
See what I mean?
I'm a day ahead.
That's why I said we still just out off track, just
Yeah.
trying to keep up. So it's just been so different, Diane, because we rip and run meetings from here to there and everywhere.
Right.
And so just being in the house more, that is not my story ever, ever. And so my body is like, okay, girl, what is going on? So good afternoon, everybody. Thank you all so much for joining us this beautiful day for the South Fulton Chambers July's Lunch and Learn, and with our special guest, attorney Dione Duckett.
Hello.
So I'm going to let her introduce herself in just a minute, but I'm going to introduce you guys to Diane Matthews, who is our chamber president. Miss Diane Matthews, how you doing?
Doing wonderful. Hi, everyone. Thank you for joining us today. You are really going to get a lot of good information. We cannot thank Attorney Duckett enough for what she is doing for the chamber, for our chamber members. So just sit back and get ready, get this information that you're going to need and act on it. And so glad you're joining us.
That's right. Take some great notes, people. Take some great notes. I got my pen ready. Definitely. So anyway, thanks, Diane. So, okay, Dion, we're going to turn it over to you.
Okay, well, thank you, Kathy. Thank you, Diane. I appreciate your inviting me to participate in this series. I am from Atlanta. Excuse me, grew up in Southwest. I had to drink some water. And just moved back to Atlanta from DC in 2015. Started my practice in estate planning and elder law. I've kind of come full circle because when I finished law school in 95, I was a corporate associate, and then I've been in and out of law. So I do the estate planning and elder law because it is a feel-good practice. I enjoy what I'm doing. It's less adversarial than other areas. My motivation to enter this area of practice, our family, my mother always took care of the older people. My father had Alzheimer's. My youngest sister had Down syndrome. Both of my parents were entrepreneurs. And so when I started the estate planning and elder law, people would ask me if I do the business law, and I would say no. But what I'm finding is business law, the planning side of it, and the asset protect side of it is interwoven with the estate planning, and your business is part of your estate. So I've now added it to my practice. To start with the disclaimer, I am an attorney. I have to inform you that this presentation is for educational purposes only, and information discussed is not to be construed as legal advice for any legal or tax matter, and viewers should speak with their professional advisors regarding specific legal or tax advice. So today I'm going to give just an overview of the different aspects and questions that you should be thinking about when planning your business. And it doesn't really matter what stage you are at startup, in the middle, growing, or getting ready to retire or get out of the business. You still want to do a lot of thinking about these things, and the earlier you can put things in place, the better. But it's never, it's often not too late. So our agenda today, we're talking about types of business structures, goals for forming a business entity or structure, and issues involved in the choice of entity. So the different types of business structures, starting with your sole proprietorship. And that's where there's one owner of the business. You haven't put any formal entity in place. I'm the owner. I am responsible for the business. I incur the liabilities. I incur the taxes and the expenses. Then there's the general partnership, which is similar to the sole proprietor, and but it's more than one person. So still, there's no formal entity. You can't have a partnership agreement. But as far as taxes, the partners are responsible for taxes and liability. The partners are responsible for all liabilities. Then there's the limited partnership. And when it comes to liability, that's where the limitations are. You usually have a general partner or partners, and then limited partners. And so the limited partners are usually people who have invested in the business, and the general partner is the person responsible, or general partners, you can have more than one, are the people responsible for the management. And if there's any liability, then the general partners are also the ones who incur the liability, whereas the limited partners are shielded from that. Then you have the corporation. That's a formal entity where the company is owned by shareholders. You've actually incorporated the business, have bylaws and annual meetings and different corporate formalities. And it's taxed at the corporate level and at the individual level. And we'll talk more about that. And then there's the limited liability company, which kind of is a combination. You can have a single member, the people who own the limited liability company are referred to as members. And so you can have a single member limited liability company, which is similar to a sole proprietorship, but it also has the liability protections that a corporation can have. And then you can have limited liability company, which has more than one member, which is similar to a partnership, but has the liability shield similar to a corporation. And I forgot, with corporations, you have two types of corporations. You have C corporations and S corporations. And we'll get into that a little bit more. Typical goals in your business planning are asset protection, tax savings, shielding from paying unnecessary taxes. That includes income, estate, compensation, and benefit planning. Then you want to look at too the ease of formation and operation. And then there's succession planning. What happens if someone becomes disabled, someone retires from the firm, from the business, or you want to sell the business. So when we talk about asset protection, there are many different types of threats. You've got lawsuits. We have a very litigious society, and people sue for just about anything these days. It can be a result of negligence from the firm, unhappy clients. It can be a number of matters. Then there's creditors of the individuals, creditors of the business. You also have predators, unnecessary taxes, bankruptcy, bankruptcy of individuals or individuals who own the business, or bankruptcy of the business itself, reckless partners or divorcing partners. So if you have a partner in the business who's a spendthrift, spends a lot of money, or just in their lifestyle is reckless. Maybe they're drunk driving or something like that, that may incur liability for that partner, which could affect the business. A partner getting a divorce, that's a potential threat to the business. And then you have probate, both living and death. What happens when someone dies or becomes incapacitated? How is that going to impact the business? What if that's a key person in the business? Then what happens to the business when that person is no longer able to manage the business? And then there could be a number of other problems. So we've got two types of asset protection that we're looking at. So first, we want to look at inside threats. And when we talk about going from the inside out. And so inside threats arise from lawsuits or creditors from within the business. And those types of people can be employees. You might have an employee who sues the company for sexual harassment, or they get injured on the job, something like that. Vendors, there may be outstanding debts from vendors. Vendor gets hurt on the premises. Customers, you may have an unhappy customer, or there may be a malpractice issue or something like that. And then there's independent contractors. Those are also people who work for the business, or work or do work for the business. And so those are all of those types of issues arise from within the business and the business activities themselves. There could be negligence on behalf of the business. You could be in a car accident where you're at fault and someone is injured during your trip from the office to meet with a client or a vendor. So that would be during the course of the business day, versus being in a car accident when you're going to the grocery store from home. And so part of your concern is the business impact of these liabilities on your personal assets. And so when you set up a business entity, or when you're selecting a business entity, you may want to put protections in place. When we talked about the sole proprietor and the partnership, there's no shield, there's no protections from liability. So the corporate forms and the LLC are forms of entities that can provide protections from business liabilities to the individuals, but you have to be sure that you are maintaining your business separate from your personal, and maintaining your business activities separate from the personal, not commingling assets, and making sure that you're following all the required formalities, so that there won't be, you may have heard of piercing the corporate veil. And that's when the courts will go through the business entity to reach the individual owners, because the corporate entity or the business entity is really just the owner. It's just an entity, and it sees through to the owner, because the owner, like when we talk about commingling, I'm trying to think of the right words. Like if you use your business accounts, you use your business credit card to buy groceries or other things, and you're not keeping things separate. So it's just like your second identity, but you're not maintaining it separate. In those instances, then the court can pierce the corporate veil to reach the individual owners. Then with asset protection, you also want to look at outside threats. And this is where we're talking about outside in. So outside lawsuits and creditors from outside of the business include a divorcing spouse. A partner could be in the middle of a divorce and have one of the assets, substantial assets, is the ownership interest in the business. And so the divorcing spouse may want his or her share of the business. And how does that impact the other, if there are partners involved, how does that impact the other partners in the business? So same thing with the bankruptcy trustee. If one partner is having financial issues and is going through bankruptcy, if they are able to attach that business interest owned by the partner who's going through bankruptcy, then they could force a liquidation of the business or become part manager. So you want to protect against those. Then same thing with IRS liens or lender or franchiser. So these are so if a partner in your business may have another outside partner, and so they may have lenders there, or they may be a franchiser, and so they may have outside liabilities that impact the inside partners, because You know, you make, like if you have 3 people who own a business and 1/3 of that is owned by one partner and he's going through a divorce or having a bankruptcy issue or tax issues and his interest gets attached, then in order to collect on that, they may force a liquidation of the business or some other kind of issue. So the concern is the personal impact of an individual's liabilities on the business assets. And so you're wanting to protect both the individual, but also the impact that it could have on business partners. So you want to be able to protect your business partners. And so one of the protections that's afforded to LLCs and corporations is called a charging order. And so, and they're different from state to state. It's based on state law. And so they protect the other owners of an entity. So they're not usually available, depending on the state law, to a sole member, single member LLC, because there are no other owners of an entity. And what a charging order is or does is when someone has been granted a judgment against an individual, then the court may issue a charging order, which limits the ability of the creditor to collect from the business to the distributions that go to that individual. So if the company doesn't make any distributions, they can't force the company to liquidate. So that protects the other partners. So if you have 3 partners or 2 partners, say Sarah and Sally, and they Sarah gets sued and a charging order is granted that allows the outside creditor, the person who sued Sarah, to collect if distributions are made to Sarah. So when a company earns money, then when the distributions are made, that's when, as soon as those distributions are made to Sarah, who's got liability under the suit, then they will be able to collect. But if no distributions are made to Sarah, then they're unable to collect. But it doesn't impact the other owners. In some states, there's the charging order is the exclusive remedy. And so that's the greatest protection, because the creditors can't pursue any other method of recovery. And so Georgia does not have an exclusive remedy statute, but we do have a charging order statute. And that's why a lot of times people do forum shopping. You'll see a lot of people who form corporations in Delaware because their laws are more friendly to corporations. Wyoming has an exclusive remedy and Florida has an exclusive remedy charging order. And then extension to single members. Some states do that. Georgia is not one of those. Okay. Then another way to protect against liability and threats is having layers of protection. So if you have a single owner, you don't really have a layer of protection unless you do things like having entities that are that own the business. So, but with multiple owners, you can fractionalize ownership, meaning someone can own 20% of the firm versus another person who owns 80%, and you can have different percentages of ownership. And so their liability and their contributions usually are based on that fractionalized interest. And then there can be classes of ownership. Usually in a corporation, you have voting or non-voting stock. When you have S corporations, you can only have one type of stock. But in a C corporation, you can have a variety of types of stock, classes of stock, including voting and non-voting stock. And so then potential membership types. When you talk about LLCs, you can have individual members who are individuals, or you can have entities like a trust. A trust can own a membership interest in an LLC. Trust can be revocable or irrevocable, and that also determines the amount of protection from liabilities. Revocable trusts usually are not do not provide protection because they are revocable, and usually you can see straight through them and to the individual owner. And then there can be other entities such as the corporation who owns a share. Okay. Income and loss allocation. So with corporations, whether it's a C corporation or an S corporation, loss and income are prorated based on the amount of shares that you own. So shareholders, just like you get your dividends are made based on the profits for the current year, and then you're taxed accordingly. And so losses also incurred are based on the proportion. So, and then when with partnerships and LLCs, you can have special allocations permitted. And what that means is in an instance where an individual owner may have significant amount of income, perhaps from an outside source. And so they may ask, they may arrange with the partnership to have a greater amount of tax allocated, tax deductions allocated, or business losses allocated to them in a current year. And in that, this is something that you would confer with your CPA about, but there has to be a substantial economic effect. It can't be for the purpose only of saving that partner taxes. There has to be some type of substantial economic effect, meaning that if the partner who is incurring more losses in a particular year, then that partner is also receiving less money. You know, he can't be maintaining the same level of income, but that he would necessarily have received, but then have greater tax liability or tax deductions than he would normally have. And then when we talk about losses and owner tax deduction of losses, one of the great things of having a business is losses can be deducted from your taxes. And so depending on the entity that you use, it also determines deductibility. So with a sole proprietor, S corporation, partnership, or LLC, then taxes are deductible by the owners. With a corporation, on the other hand, whether it's a C corporation or an S corporation, then taxes are only deductible at the corporation level because the individual owners are shareholders and they don't receive income until they receive distributions. And so they're not involved in the management of the corporation. And so at that level, they are not receiving tax deduction of the losses. The other thing there is that, I lost my train of thought. Oh, when we talk about the LLC and the pass-through elections, so now LLCs can actually elect whether they are treated as a C corporation or an S corporation or as a partnership. And so if they elect S corporation or partnership status, then they have pass-through where we talked about then they have passed through where the taxes on the individual level. With the corporation, on the other hand, if they take C corporation election, then it's not a pass through. So there's double taxation. So the corporation itself is taxed based on the revenues and income, based on the income that it brings in. And then when distributions are made to the individual shareholders, they're taxed again. So that's where we talk about the double taxation. So often, so that's why people often work as a sole proprietor, S corporation, except that those two, not the S corporation, sole proprietor or partnership, those provide no liability protection, whereas as the S corporation or the LLC, they provide the liability shield, and then they're also pass-through entities, so you don't incur the double taxation. Okay. Then another tax concern that you look at when business planning is the employment taxes. So employers are required to pay FICA, Social Security, and Medicare for their employees. not for independent contractors, those are responsible for their own, but then what about the owners themselves? So in a corporation, whether it's a C corporation or an S corporation, then the owner is usually an employee if they are if they actually are not just an investment owner. And so then they pay individual income taxes, but the entity pays FICA, Social Security, and Medicare. But then on the other hand, if you're self-employed, then the owner pays self-employment taxes for themselves, and then they still pay FICA, Social Security, Medicare for the employees, but the owner themselves the owner is not an employee. The owner takes owner draws. And so when the LLC does not elect S corporation status, then it's a pass-through election. And when it does not take S corporation or corporate C corporation status, then it's treated as a pass-through and the owner pays self-employment taxes. And self-employment taxes tend to be a little bit higher than the FICA, Social Security, and Medicare. Okay, and then there's taxation of fringe benefits. Fringe benefits are the non-salary benefits that employees get. So, so for owners of corporations, whether C corporations or S corporations or LLCs that that elect C corporation status, then or C corporation treatment, then fringe benefits are tax-free for the owners. So when they receive those fringe benefits, a fringe benefit can be health insurance, an employee car, anything that's a non-salary benefit. It could be tuition remission, those types of things. So things that are non-tax, non-salary benefits, then the owners don't pay those. With the S corporations, it's only shareholders who own 2% or less of the corporation. And then for the other entities, fringe benefits are taxed to, oops, sorry about that. Fringe benefits are taxed to the owners. That's in the case of the sole proprietor, partnership, S corporation shareholders who own more than 2%, and the LLC that has the pass-through election. Okay, then estate tax savings. Most people do not have a concern these days with an estate tax savings, and that's because the estate tax exemption now for individuals is $11.58 million. And so before the estate tax exemption went to $11.5 million, it was $5 million adjusted for inflation. And so, and at that point in time, 99% of Americans did not have a taxable estate. So now at 11.58 million, I don't know what's less than 90, more than 99%. It's not quite 100%, but most people will not have a taxable estate. And when you have a couple, it's double that, a married couple. The highest estate tax rate is 40%, but of course we have to reach this threshold first. And then there's the gift tax exemption. So there's $15,000 annual exclusion currently. And what that means is each individual can give to as many different individuals as they like per year for $15,000. They can give $15,000 without having to file a gift tax return. If you were to give someone $16,000, then you would have to file a gift tax return, because then that goes to the $11.58 million. That's a lifetime exclusion, and it includes all gifts and all, and then the total value of your estate at your death. And so those gifts that are over $15,000 get counted. And so with a married couple, of course, that's double. You can gift split. And each, for instance, if you want to give $15,000 to a grandchild, if you're a married couple, you can give $30,000 to a grandchild, and that will be excluded. And it would be split amongst the two spouses or two grandparents. And then again, the $11.58 million is the lifetime exclusion. Okay, So business entities in estate planning, there's a variety. So often people use a family limited partnership. And one of those, what that does, for instance, if you have property, my family, for instance, has my father, there's 7 kids, and there's a 30-acre farm in Covington. So, and everybody has a different idea about what they want to do with it. But often families, whether it's a business or a piece of property, they may form a family limited partnership. And so again, with the limited partnership, we mentioned earlier, you have a general partner that is responsible for management and incurs liability for any for any of it. They're responsible for the liabilities of the partnership. And then you have the limited partners who are shielded from that liability and own shares in the partnership as well. So if you have a family business, then having a family limited partnership, instead of leaving the business to the children, you can leave the partnership to the children. It also makes it easier for a child who's not interested in the business to sell their interest in the business to the other family members, and the partnership agreements would have outlines and the structure for doing those things. Same thing for LLCs for holding real estate. What that does, for instance, if you have several real estate holdings and then you have your own residence, you don't want to. Real estate is a highly it's high risk property. So if accidents happen with tenants or other people on your real property, and you're not shielded from protection by an entity such as an LLC, then if someone sues you and gets $1 million or $2 million recovery, and you have $1 million worth of insurance, then they will go through and say your house is worth, your residence, your personal residence, or your other property is worth $1 million or more. Then if they're given a recovery of over the amount that's covered by your insurance, then they may seek to attach your personal assets. So by holding real estate, especially rental property, in an LLC, you're able to shield your individual property from the business property. And for all of these things, timing is very important, because we talked about piercing the corporate veil. And I'll get to that a little bit later, but timing is important, because if an accident happens and then you go form an LLC and transfer your property to it, then the court is going to pierce the corporate veil, because now they'll consider it a fraudulent transfer because you knew you had a liability coming up and you transferred to avoid that liability. Same thing as LLC for business operations. We talked about inside out and outside in obligations. And so an LLC can have living trust or a family limited partnership as owners of, as members or owners of the LLC. And then when we talk about corporations for business operation, they can also be owned by trust. And so those are all ways to layer and put protections between the individual and the business. Okay. Then when we talk about ease of formation, that is a consideration that people should take, because when you form a business, now with the sole proprietorship and a partnership, there's not necessarily requirement for, with a partnership, you typically want to have an agreement, but a lot of times people have informal partnerships, but the more you have in writing, the better you are protected. But as we discussed earlier, there's also no shield or protection from business liabilities to the individual when you talk about a partnership. And so, but with the other entities, the LLC and the corporations, there are corporate filings required to start up the business organization. You have your articles of incorporation for for your corporations, articles of organization for your LLCs, partnership agreements. And then there's annual filings that have to be done. With corporations, you may have to do annual meetings. You need to maintain your minutes. You need to have bylaws, operating and partnership agreements, organizational resolutions for decisions of the organizations. And so it's important to have meetings and to follow all of those corporate requirements in order to maintain the corporate status and to protect yourself from piercing the corporate veil. When you form the corporations or the LLCs or other entities and don't follow the formalities that are required, the annual filings, the meetings, and the documentation, and your tax returns, then you jeopardize the protection that you're afforded that the individuals are afforded, and so you've kind of wasted the development of the entity, because again, the development of the entity is for protection from liability, to shield liability, and to minimize taxes. All right, then succession planning. Succession planning, you really should start when you start planning your business, you should kind of think about how you want to end your business. And that may be years down the road, but often people don't think about, well, when I get ready to get out of the business, what do I want to do? Do I want to sell the business to another person or entity, or do I want to liquidate and sell everything, sell all the assets of the business? And so with succession planning, it's just like estate planning in that you have to think about what happens if an owner becomes incapacitated or dies. What happens if an owner decides to retire or leave? And that can be a voluntary leave. That could be an owner being forced out because they're not acting appropriately, or just disagreement between owners. And then you look at how transferable is the interest. And so when we look at incapacity or death, if a key person who's running the organization, or if it's a single member LLC, if something were to happen to that person, then what's going to happen to the clients? What's going to happen to the business? What's going to happen to the obligations of the business, to the clients? And then also what's going to happen to the family? If this is the primary source of income for the owner's family, then what's going to happen there? Same thing if somebody decides to retire. And through your agreements and your documentation, you can have buy-sell agreements that are used a lot in the succession planning, and it sets forth the terms for if someone retires, how will other owners buy that person out if there are multiple owners? If someone's leaving in bad standing, how would you handle that circumstance? Are you going to have non-compete agreements? Because if someone retires and has all of the trade secrets, and then they go consult another firm, how will that impact the owners who are left with the business? And so there's many issues that you want to think about. But in general, you need to think about succession planning for incapacity or death and when you plan to leave the firm. Okay. And then when we talk about doing all of those things, you should have a team, because no one knows everything about all of it. And so the team can involve the client, of course, the business attorney. And so the client, meaning the business owner, the business attorney, an estate planning attorney, CPA, who can help you with the tax issues. The estate planning attorney can help you look towards what happens when you become disabled or die. The business attorney help you with this business formation. Then you've got your financial advisors who are assisting, who may be who may know all of your financial holdings and help you plan for wealth generation. Insurance professionals. Insurance is often the first line of defense for your liabilities, but then you also want to have an umbrella policy. So if you have, for instance, malpractice insurance that covers or premises liability insurance that covers $1 million or a few $100,000. Well, what if all of your assets are worth $2 million and you get sued and someone's awarded a $2 million award? So then if you have liability insurance that covers $1 million, then they're going to look towards your assets for the rest. And other professionals, depending on what your field may be. It could be a patent attorney, it could be something specific to your business, and then also other family members who may have input into what you're doing with the business. I need to change the client to the business owner there. And but it's always good to have a team. Often you may have attorneys who there are attorneys who are CPAs. There are attorneys who do business and estate planning. There are financial advisors who are CPAs, and there are many financial advisors who also are insurance professionals. And so, but you'll often need a team. And so I'll give you an example of someone I know who recently, when you talk about business succession planning, when people get to the stage, especially if we're talking about retirement age, that they have a business and they're ready to retire, then sometimes parents want to leave the business to the family, but family members may not be interested in the business. So then what do they do? The other thing is, having a CPA in place. A lot of people are hesitant to pay the fees of an attorney or a CPA, but doing the planning in advance can save you a lot on the back end. And a recent example that I know of is someone who sold a business for twice what they invested. They owned the business for about 40 years, invested $1 million into it, sold it for $2 million. And at the end of the day, because they just sold it outright and didn't confer with anybody, they ended up with about a $400,000 tax bill. And so if you confer with your CPAs and you confer with business attorneys, then you may be able to, and well in advance, like a year in advance, if you're thinking about retiring, don't wake up one day and say, okay, I'm going to sell. and you plan it, then you can usually structure it so that you have tax savings. And so that is pretty much it. Are there any questions?
No, that was awesome. That was a lot of great information. So the good thing about it is that, people can definitely go back and do the replay on the Chamber's page. And I did post on Facebook that if anybody have any questions, to post it there underneath our post, and that you will follow up with them. So if anybody posts anything, I will make sure you get the question, and so you can follow up with them.
All right.
And I did post here inside the Zoom room. If anybody have any questions, please post in the chat box, or at this time, you can really unmute yourself and ask your question personally to Attorney Duckett. Any questions? Ellen said, just wanted to say thank you for all this information.
Okay,
Awesome.
thank you. I know it's a lot and it covered a lot of different areas. And so, but there are a lot, it's just to make you aware of the questions you should be thinking about when getting into the planning.
No, that's awesome, because here again, a lot of people we don't think ahead like that. When we're setting up business, so many people are fueled by passion and, wanting to get it done and get it set up. And I was having a conversation with someone earlier this morning. We don't really think about you know, all the true things that we do need to have set up when you're really setting up a business. So a real business. I'm not talking about a hobby or a side hustle, as people call it. You know, I'm talking about a business.
Yeah, for a lot of people, the business is the main source of income for the family. If they've got a going, you know, that can be, you know, anyone from hairstylists, you know, salon owners, doctors are often, you know, independent. Basically, they're entrepreneurs, unless they work for an organization. Many doctors who work for hospitals, they work for hospitals as independent contractors. So they have their own business. Same, many dentists, they're not part of a franchise, you know, they have their own daycare centers, all of those, you know, and then, you know, daycare centers, there's a good chance for liabilities, and even all of those other things. There's liability protections that you want to think about, and the tax protections.
Wow, yes. So Jasmine, who's in banking, said this is a great tool to share with her customers. So I also have a referral source for customers who have legal questions. So yeah, so she would definitely be able to utilize you for that.
Okay, thank you.
And then Miss Judy. Thank you, Judy, for joining us. She was said phenomenal information. She learned a lot of new information, you know, today. So
right, yay.
All right. So this was awesome. Diane, any closing words?
I have a question.
Okay.
Hi, this is Judy.
Hi.
Thank you very much again. A lot of new information I hadn't heard before, as Kathy just stated. I wanted to know, when you talked about that team, your team having cross specialties, what are some of the specialties that you have that will be a crossover? Like the example you gave, the lawyer may be,
okay.
You know what
All
I'm
right,
saying?
so my crossover, I am primarily in estate planning and elder law. I have background in business. I started off as a business attorney, and I work with, I associate with a business attorney who is also a CPA. I also have a master's in accounting, but am not a CPA. So I have a foundational understanding of a lot of things, and so I often know what questions to ask and know when to get somebody else involved. And so, but I am primarily here in the estate planning and elder law, and I work very closely with a business law attorney. And so, so if it's something that I am not well versed in, then that's when I call him in. And then CPA, your taxes, you always, and I do know tax attorneys as well, but a good CPA is always a good person to have for a business.
Awesome, thank you.
Thank you.
Well, we just want to thank you again, Attorney Duckett. This has been wonderful. This is some great information. And like Judy said, a lot of it is information we haven't heard before, even though we've had estate planners before present to us. So this is a wealth of really good, current, on-time information. So if there's anyone that has any other questions, let us know. And you know how to reach out to Attorney Duckett. I think her contact was on here earlier, and I've already reached out to you myself. So I encourage everyone to do that.
Thank you. Thank you very much for inviting me. I appreciate being able to do this. Doing Zoom for presentations is a little bit different, but but it's also an efficient way of presenting.